59 of the Clean Water Act relates to restricted land uses. This term is used differently under the Clean Water Act than it is for land use planning. Simply put, in the context of source protection plans, it is a flagging mechanism. It is designed to flag any proposed developments that could include an activity that is prohibited or that requires a risk management plan under Part 4 of the Clean Water Act. Restricted land uses ensure that the development plans don't proceed until source protection concerns are addressed via the risk management official. It is necessary to use a screening process to ensure that the risk management official receives the required information. This means that help from the departments responsible for planning and building applications is needed. The following slides outline the screening process. This workflow chart is a reference tool for municipal staff. Effective application of Part 4 policies is a team effort between the risk management official and the development review staff. At the earliest opportunity, municipal staff must first determine whether the subject property is within a vulnerable area where Part 4 policies apply. The easiest way to do this is to check the interactive maps on the Clean Water Cataraqui website. If it is outside of the area, then regular municipal procedures apply to the proposal. If the proposal is within a vulnerable area with Part 4 policies, proceed to Step 2. In Step 2, the municipal staff person will assist the development proponent to determine if any Part 4 policies could apply to the proposal. Everything you need for this consideration is available on the Clean Water Cataraqui website, including the interactive maps as well as the restricted land use fact sheets, which will be explained on the next slide. The interactive maps and restricted land use information sheets were developed based on information in the Cataraqui Source Protection Plan. It is important to remember that there are limited source water protection considerations for residential uses in wellhead protection areas and intake protection zones. On the Clean Water Cataraqui website under the Resources tab, specific fact sheets for each vulnerable area have been developed by CRCA staff. These fact sheets identify which activities fall under Part 4 policies in the Cataraqui Source Protection Plan and provide example land uses. This document can be referred to when screening a proposal. Once the appropriate restricted land use information sheet has been selected, determine if any of the activities listed are associated with the proposed development. If Part 4 could apply to the proposal, proceed to Step 3. If there are any questions regarding the applicability of a Part 4 policy, contact the risk management official. After reviewing the applicable restricted land use information sheet with the proponent, if Part 4 clearly does not apply to the application, i.e., they will not be using any of the chemicals identified as a significant drinking water threat, or their proposed activity is not included on the restricted land use information sheet, the proponent must fill out and sign the Restricted Land Use Declaration form. The declaration form will ask the proponent to indicate that they understand the activities that fall under Part 4 of the Clean Water Act in the applicable vulnerable area, and that they agree not to establish any of the activities of concern in the event that the proposal is approved by the municipality. This form helps to provide a paper trail for proposals that don't require further screening by the risk management official. After the declaration form has been read and signed by the proponent, keep a copy of the signed form on file. A copy of the signed form must also be provided to the risk management official for their records. Regular municipal procedures will now apply to the application, as source protection concerns have been addressed. If any of the activities identified in the Cataraqui Source Protection Plan will be associated with the proposed development, it is necessary for the municipal staff person to help the development proponent fill out the Restricted Land Use Submission form, which can also be found on the Clean Water Cataraqui website. The form is 4 pages long and includes sections for contact and property information, a description of the proposal, the reason or reasons that the proposal was flagged, a list of attachments, room for a site drawing, contact information for the Risk Management Office if there are questions. It is to be submitted to the Cataraqui Region Conservation Authority Office to the attention of Holly Evans, the Risk Management Official and Inspector Lead. After receiving the restricted land use submission form, the risk management official will review the development proposal. Within 10 business days of receiving the form, the risk management official will provide a letter or notice to the proponent and copy the municipality. The letter or notice will indicate one of 4 possible outcomes. The proposal is not affected by policies in the Cataraqui Source Protection Plan. The proposal involves activities that are already covered by a risk management plan. The proposal includes prohibited activities and cannot be engaged in at the proposed location. Or the proposal includes an activity that requires a risk management plan. If the letter or notice states that no further action is necessary for source protection, either because the proposal is not affected or the threat is already addressed by a risk management plan, regular municipal procedures may resume. If the proposed activity is prohibited by the source protection plan, the application cannot continue. If the proposal requires a risk management plan, proceed to Step 5. Step 5 only applies if a risk management plan is required. The person planning to undertake the activity of concern will negotiate a risk management plan with the risk management official. Once the plan is agreed to by both parties, the risk management official will provide the proponent with a copy of the risk management plan along with a notice. Once the development proponent provides the municipality with a copy of the notice, regular municipal procedures may resume. In general, Part 4 policies should be straightforward to implement, with current activities of concern already noted and ready to be addressed, and future activities appropriately flagged by Section 59 restricted land uses. However, if necessary, Part 4 of the Clean Water Act provides risk management officials and inspectors with enforcement powers. The Clean Water Act permits trained people to be appointed as risk management officials and/or inspectors. In the Cataraqui Source Protection Area, staff have been appointed to fill both roles. The Clean Water Act provides different responsibilities for risk management officials and inspectors. Risk management officials are the administrators, while risk management inspectors ensure compliance. This slide presents an overview of the general roles and the orders that can be issued by either a risk management official or a risk management inspector. Risk management officials are responsible for ensuring that risk management plans are in place as per the Source Protection Plan. They also must issue notices and letters to support restricted land use policies. If a risk assessment is submitted under Section 60 of the Act to lower the vulnerability score of a particular area such that an activity is no longer considered significant, the risk management official must consider acceptance of this assessment. Finally, the risk management official must prepare an annual report about Part 4 implementation and submit it to the Source Protection Authority by February 1st. To support the risk management official's responsibilities, the Clean Water Act includes provisions that in order to require a disclosure report explaining a complex operation can be made to inform risk management plan content. The Act also enables risk management officials to cause work to be done to support a risk management inspector enforcement order. This means that the risk management official is performing the work necessary to comply with the order. Risk management inspectors ensure compliance with Part 4 policies. This is accomplished by performing inspections and, when necessary, by issuing orders to cease and desist an activity to comply with the prohibition, or to set out directions to achieve compliance with a risk management plan. The risk management inspector is responsible for prosecuting offenses under Part 4. Part 4 offenses include failure to comply with Section 57 prohibitions, failure to comply with Section 58 risk management plan requirements, failure to comply with a Section 63 enforcement order, failure to comply with a risk management official order to provide a report under Section 61, and obstruction or submission of false information under Sections 90 and 91. Offenses under the Clean Water Act are prosecuted under the Provincial Offences Act. Risk management inspectors are provincial officers under the Provincial Offences Act, and the risk management inspector may begin a prosecution under the Provincial Offences Act if a person commits any of the listed offenses. The Clean Water Act sets out the penalties for offenses, including fines up to $25,000 a day for an individual's first offense, up to $50,000 a day for subsequent offenses, or fines up to $50,000 a day for a corporation's first offense, up to $100,000 a day for subsequent convictions. When a person falls under Section 57 or Section 58, i.e. prohibition or risk management plans, they have the option of preparing a risk assessment under Section 60 of the Clean Water Act. The risk assessment issues a challenge to be excluded from Part 4 policies. This requires changing the vulnerability score of their area and proof that the proposed activity would not be a significant drinking water threat. This is a situation that could occur as the assessment report becomes outdated. The risk assessment is meant to determine whether or not the assumptions that were made in the assessment report for vulnerable areas were accurate for a specific site where an activity is occurring. The risk assessment is not questioning whether or not the activity would be a significant drinking water threat in a vulnerable area. It is verifying if a vulnerability scoring for an entire vulnerable area is applicable to a specific area, if that specific area does not have the same vulnerability characteristics as the rest of the vulnerable area. Under the Clean Water Act, orders from the risk management official or inspector can be appealed to the Environmental Review Tribunal, an independent and impartial body. A person has a right to apply in writing for a hearing before the Environmental Review Tribunal to appeal orders from the risk management official within 60 days of receiving them. A person requesting a hearing before the Environmental Review Tribunal must state in their notice the grounds on which the person intends to rely at the hearing. The Environmental Review Tribunal may confirm, alter, or revoke the risk management official's decision. Once the tribunal has made a decision, it cannot be appealed. All residents within 120 meters of the relevant site and all interested parties, including the municipality and the Source Protection Authority, will be given notice of the hearings. Hearings will be held within the community where the activity is taking place. Residents and interested parties can be observers or participants in the hearing.